In the remaining time, I'd like to give each of you the opportunity to give us a summation, so to speak, some key takeaways on what you'd like to leave with the attendees as major points. So we're going to do it in the order of the segment. So we're going to start with Dr. Agatha Liu. Dr. Liu, some key takeaways, please.
Sure, thank you, Sal. What I like to say is that whether you're working on new ways to simulate natural intelligence or just mining data to detect patterns and characterize human behavior, I would encourage you to keep in mind the original goal of patent protection, which is to reward useful ideas that no one else has thought about before. These days, few ideas are truly preemptive because of the difficulty of determining the precise rules of nature and the advancing technology that allows mostly incremental improvements. So to obtain patent protection for AI inventions, and perhaps just inventions in general, the point is to clearly claim the inventive point and demonstrate why they're inventive in the specification. So once again, I encourage everyone to start with this principle and keep making the world a smarter place. Thank you.
Thank you, Dr. Liu. Let's go to Andy Gabriel now. Some key takeaways, Andy?
Okay, yes. I think in terms of disclosure requirements that I had talked about, the key thing I try to keep in mind is all of those requirements are tied to the claims. And so going into the patent application process, you're going to have a general idea of what you might like to claim. You need to recognize, though, that as the law changes and develops, the patent has a life, of about 20 years. So it's important to try to keep that in mind, that what you go in expecting to get might not be what you come out with, and even if it comes out, the law might change as the patent exists. So when trying to forecast what to put into the written description, I tend to err on the side of putting more and more examples in, if possible. That being said, I do favor having a pretty focused application to support reasonably scoped claims, because those tend to have a lot fewer problems than larger applications that try to claim very broadly. So I would just try to keep that in mind. And then, of course, as I had said near the end of the talk in my segment, there does have to be some consideration for keeping things back as trade secret, given the current eligibility environment that's going on right now. So those would be the key takeaways that I can recommend. Back to you, Sal.
Thank you, Andy. Larissa Park, take a minute, please, for some key takeaways.
Sure. So I wanted to thank everyone for participating for the past 2 hours, and the other speakers for having such great, insightful comments on AI. So this has been great. I think the big takeaway I would say is that these are patentable inventions. You shouldn't be concerned about their patentability. The climate is only getting better as we move forward. So I think that the courts are becoming more and more receptive to these types of inventions, and the patent offices as well. So we should continue trying to protect these types of inventions going forward. But echoing on Andrew's thoughts, they have to be presented in the appropriate way. So we need to make sure that we put the right amount of details and are claiming them appropriately to make sure that we continue to see the courts accepting these types of inventions and the patent office doing the same. So thank you.
Thank you, Larissa Park. And finally, Paul Kravitz, a minute for some key takeaways, please.
Well, the term artificial intelligence, as we discussed, is very difficult to define in a patent application. So you have to work carefully with the inventor. If you want to use that term, define it in a manner that is not overly broad and not overly narrow. Consider whether to include the term in a claim, because it caused some issues, as we talked about. So a good approach is not recite it in an independent claim, but recite the term artificial intelligence in a dependent claim. Consider including a whole range of claims, some that do not recite specific AI technologies, like a neural network is a specific AI technology. So add claims that don't recite that type of technology, instead recite detecting a sign, recognizing a sign. And also consider claims that do recite the specific technology, such as a neural network. And we talked about adding a means plus function claim can provide significant value as long as it's an extra claim. And then you got to be very careful to draft your claims to cover the various different parties with AI. It's very distributed, many parties involved. A vehicle, a black box maker that's installed in a vehicle. We talked about a mobile terminal that interacts with the vehicle, an application that's downloaded from the Apple Store or another app store. So you got to cover claims to cover all those parties. Computer readable medium claims are very important in AI applications. For 101 to satisfy that includes sufficient technical recitations in the claims, but be careful. Too many recitations can change which party would infringe your claim and make the claims basically not very useful.